Are we supposed to use this one or not?
They said that one's working and this is
Okay.
for the camera.
Oh, okay. I think I have a loud enough voice. I don't need either. So my dad is Roger Barron. He's a graduate of Mizzou Law School, 1976. I actually graduated from Mizzou Law School 30 years later in 2006. He is licensed in Missouri, Texas, South Dakota, and the United States Supreme Court. Prior to going into teaching, he practiced law in Missouri for 9 years. He then taught for 5 years in Houston at South Texas College of Law, then taught for 25 years at the University of South Dakota College of Law in Vermilion, focusing on civil procedure, family law, and insurance. He retired 2.5 years ago in May of 2015 and is now living in Arkansas, 25 miles from Razorback Football Stadium, but he remains active, serving the law school and the state bar in various capacities, including the continued operation of USD Law Listserv, providing South Dakota Supreme Court summaries on a weekly basis, reporting on those decisions as they are handed down. And he also remains involved in the practice of law with continued work on ERISA subrogation matters in state and federal courts across the country. And he, Professor Barron, will be describing this in today's presentation. So without further ado, Professor Barron.
Oh, thank you very much. It's so great to be here. So many good friends and former students, and I feel like I'm in front of a Supreme Court. I got 5 judges over here somewhere, so I'll try to make sure I say things correctly. I would like to honor or recognize Judge Whip Fifley. Thank you for being here. Judge Guzinski, Judge Mandel, Judge Tellinghusen. I don't know, are you here?
I'm here.
There you are. Okay. I should have recognized you. And Judge Woolman. So I'm honored, definitely honored that you're here. Matt Vance. I was going to talk about Matt, but Ken, you did, and that's great. Matt graduated law school in 1997. He worked for 4 years at the United States Department of Labor in Washington, D.C., which is pretty impressive for a kid graduating from the University of South Dakota Law School. And our paths have crossed. I do a lot of interaction with the United States Department of Labor and this ERISA work. I am a registered user on the Department of Labor database. I kept requesting documents, and finally somebody there said, why don't you just register and you have free access to everything? And so as people are contacting me for help, that's one of the things I tout is I'm a registered user of the database, and we don't have to hang around with the free ERISA.com, which is kind of dicey anyway. Matt, the last 18 years has been doing nothing but ERISA work. The scope of his work is much broader than the scope of my work. I'm in a very tiny area. So he is truly an ERISA expert. I spoke I wrote this down, Woodbridge, New Jersey on June 11th, 2009, and Matt was there. It was an afternoon presentation, and then I had the honor of being taken down to Manhattan and spoke at another presentation, made another presentation on ERISA in downtown New York, which was a great privilege for me. So Matt's been to 2, this will be your second presentation. Thank you for coming, Matt. I'm just delighted that you're here. I'd like to recognize my son-in-law, Josh Huey. Josh graduated from USD Law School in 2006, editor-in-chief of the Law Review. Unfortunately, when he graduated, I couldn't attend the ceremony because we were down in Columbia, Missouri, attending Sarah's graduation, also in 2006. They graduated on the same weekend. And then they came home and got married a couple weeks later, and then their honeymoon was studying for the South Dakota bar exam. So not the best way to do it, but that's the way they did it. Claudia, thank you for being here. She's come to, this is my 25th professional presentation on ERISA. She's come to the ones that had attractive destinations. She came with me to Seattle, to Atlanta, to to Las Vegas. Sorry, that tragedy there is something horrible, but in fact, the whole family came to Las Vegas, Sarah and Josh and our other daughter. She did not accompany me to Duluth, Minnesota, nor to Wichita, Kansas. I don't know, but I got to do those. David Berari was my research assistant for 2 years, and he also joined us at a presentation in Coeur d'Alene, Idaho, where I had the opportunity to speak to the Oregon trial lawyers. So David, thank you for being here. Now, you might think it's interesting to have a daughter who's a lawyer. I want to tell you the other side of that. Here's a t-shirt. It's kind of dirty because I wear it all the time. Here's a t-shirt that my daughter gave me. And I wear it on the farm in Arkansas, cutting wood and everything. But every time I wear it, she said, "Roger, I don't know how reliable those rankings are." I don't know how reliable those rankings are. So thank you for the t-shirts there. Yeah. Thinking about my work in ERISA, I'm reminded of a fellow named Jesse Smith who worked at the beer manufacturing facility in St. Louis. And Jesse had the unfortunate occasion to fall into one of the giant vats of beer and die. And so the supervisor went to Jesse's home, knocked on the door, and Mrs. Smith came there and he said, "Mrs. Smith, I'm very sorry to report that Jesse fell into a large vat of beer and he drowned. He died this morning." And she was just shocked, and she said, "Well, goodness, couldn't he swim and climb out?" And the supervisor said, "Well, that's the really strange thing about this situation. He got out 3 times to go to the bathroom before he died." At this point in time, I feel like I fell in the federal court. I've climbed back out several times, and I'm going to go back in. I'll probably end up drowning there before it's over, but I'm enjoying this. I have been blessed with this area of expertise. It's a unique fit. It deals with insurance, it deals with federal procedure, it deals with federal preemption, it deals with federal court, ERISA subrogation, so it's a natural fit into my assigned teaching areas. And so I started publishing in the early 90s on the topic of subrogation, and then that expanded. Aside from the JAG school, which is accredited, there are 207 accredited law schools in the United States, 207. It's an overwhelming number. Each law school has a faculty that's far greater than USD's faculty. There are, at last report by the ABA and the American Association of Law Schools, over 7,700 full-time law professors. And that excludes deans and librarians who also teach. That would mean an average law school faculty is around, I did the math, 33, 34 at least full-time professors. And one aspect of being in academia is to find your niche, your area. I think of those 7,700, about 3,000 of them are all clamoring for a niche in constitutional law. You know, that's where they want to be. That's where they want to make their, stake their claim to fame. But this has been my niche, and I continue to be amazed that, so far as I know, I'm the only permanent law school faculty member, now retired, who has been interested in this area of the law. And that is still the same today. And so this has been the area in which I have definitely been interested, and I've been so grateful that I found this niche. And to some degree, I'm grateful that I stand alone. Now, since I've gotten involved, there's been some really bright professors who've published some law review articles on this area of law, and so I should acknowledge that. But in terms of fully devoted to this area of the law, nobody has really just signed on to this area of the law the way that I've done that. And, it's not an inconsequential area. A huge segment of our society, we don't know who they are right now, if that hasn't happened in them yet, but a huge segment of our society become tort victims. And when these tort victims find out that their recovery is going to be taken all or part by an insurance company, an ERISA plan, which then channels the money into areas a lot of which is executive compensation, and other areas for profits and not back into the benefit of the other ratepayers, then it seems very unfair. And so this area that I work in terms of the industry's own statistics, collects over $1 billion a year in subrogated recoveries for these ERISA plans. And that statistic comes from a brief filed by the United States Chamber of Commerce in the U.S. Supreme Court. And it's ongoing, and if anything, it's gotten greater and not larger since that brief has been filed. So that's my niche. Today, I'm going to talk about this area from a different point of view, from the point of view of as a practicing lawyer. Like I said, I've presented 24 other times. The last time was in May of 2011, so it's been almost 7.5 years since I made a presentation, and that was in Fargo, North Dakota. And I don't know why Claudia joined me on that one. She went to Fargo. We had a lot of fun, but that was my last presentation on this area. And so now I'm coming back to this. I haven't gone away from the area, but I'm coming back to this in terms of presentations. My work is primarily with the situation where there's been a health plan or health insurance company that's paid money as a result of damages or injuries inflicted by a tortfeasor. The victim is in the process of recovering or has recovered money from a tortfeasor, and now this insurance company or ERISA plan wants that money, and we'll look at its right to collect that money and any protections, if any, given to that. Now, I'm not going to talk substantive law here today so much. My last presentation in Fargo was 2 hours. This isn't going to be 2 hours. It's going to be about 30 minutes. That's the hope anyway. But what's interesting to me, anyway, it's all interesting to me because I like this stuff. This is something that started from the top down. I didn't start working on this on the lower level by working on lower level cases. My entry into this area of the law, especially in the federal court, became as a result of my involvement in U.S. Supreme Court decisions and cases that were proceeding there. And after I did that, then I started developing the ability to assist people at a lower level. There's a packet of information on the tables. There are 4 documents in each one of that packets, and I'm going to talk about those documents. The first 2 documents are only 1 page long, so they're pretty easy to look at, and I'll tell you when to look at it when it's time. And the third document is 14 pages long. It's a little bit longer, and then the last document is 10 pages long, but each one of your tables have that. The idea of being in ERISA, or being in federal court, was not even on my radar until November of the year 2000. And I received a cold phone call from an attorney in Los Angeles, and his case that he had prevailed at the Ninth Circuit level. The other side filed a petition for writ of cert with the Supreme Court, which the Supreme Court granted. And the conversation, I remember it very well, was, Professor Barron, you have the only law review articles or research that I found anywhere that address the appropriateness, the public policy behind subrogation on health insurance. And we want to defend what the Ninth Circuit did, and so we would like for you to help us. And he asked me to help him write the brief and prepare him for handling the case. And I said, I'd love to do it. I want to check with the dean. Dean Vickery gave me the green light, and so I signed on to that undertaking. And then in January, for some reason I've never found out, I'm sure it's not because my name was involved, but the other side changed its mind and dismissed the petition. And that's kind of unusual because the Supreme Court only grants cert in 1% or less of the cases where the petition is granted or is filed. But it changed its mind, and so that case went away, and the result was the favorable Ninth Circuit decision remained in effect. But that was my first exposure, and then I got interested in it and then published a law review article in Mercer Law Review that dealt with subrogation in the area of ERISA. Since then, I've been involved directly in 3 U.S. Supreme Court proceedings. My most intimate involvement was in the Sereboff case. In that case, I helped the attorney brief the case. Sarah was a third-year law student. She accompanied me to Washington, D.C. We met with the attorney the day before argument, and we helped prepare him for oral argument. And we sat in the courtroom during the oral argument. It was one of the first settings where newly appointed Chief Justice Roberts was on the bench, and so we got to experience that. There were two cases on the docket that day, this case, which was first, and then the second case was kind of a famous case involving detainees at Gitmo, Rumsfeld versus Hamden, something like that. And so the court allotted extra time for that argument. So that was quite an education for us to be there for that event. Now, as a result of being involved in the Sereboff case, I've got all kinds of invitations to speak, and I took them up. I went, I took the opportunities. First with the Association of American Justice, the trial lawyers organizations in various states, and that's how I got these invitations to travel around and to speak, and I've enjoyed doing that. And I've published many articles on topic, both in law review articles and also in special journals published by these trial lawyers organizations. They like to publish me, and they'll usually publish the same article, be published numerous times in the various state trial lawyers organizations. My record of success in the Supreme Court is absolutely dismal. 0-3. Not only did we lose every case, but it was almost always a unanimous vote against our position on any issue that counted. And so that's who the trial lawyers will say, come speak to us, you're involved in that case. Okay. But I want to point out that in each one of these cases, the posture of the case was federal litigation was started because the plaintiff's lawyer settled with the tortfeasor, received money into his account, and then did not want to honor the terms of the plan. And so by the time they're dragged into federal court, they were dragged into federal court, and usually the attorney's always sued with the client. The attorney and the client have been sued for breaching the terms of the plan document. And that's the basis for getting them into court. And so you've got egg on your face when you get into federal court. All of these cases that I worked on in the Supreme Court involve that scenario. And that's a scenario, every time that I have spoken, I've recommended against that. I've disavowed that scenario. In fact, I like to think in terms of, I don't know if it's the best analogy, but when a plaintiff's lawyer is about ready to receive money and to release a tortfeasor, and as soon as he does that, he puts himself in breach of the terms of the plan, unless he's willing to take care of the lien. It's like you got an angel on one shoulder and the devil on the other shoulder. And the angel saying, don't do this, wait till you resolve the lien first, or get that squared away. And the devil saying, get the money, forget about the lien, maybe they'll forget about it, we'll figure something else later, just grab the money and run. If the plaintiff's attorney makes a deal with the devil, there may be hell to pay. And that particular hell is in federal court when they're sued. And these plans are very good at hauling them into federal court on getting a TRO and an injunction and prevailing. It's very difficult to ever be successful in federal court when you breach the terms of the plan document. I have started since that time working on the lower level. This was in September of 2009 that I first got involved directly with the case in Seattle, Washington. And I mention this because I've been looking at Wikipedia on Judge Viken. And if those statistics are accurate, this is the same time he assumed office as a federal judge in September of 2009 as when I started working directly in federal court. We had a case in Seattle, and I want to mention Vern Goodsell because he and I had a case that was very, very successful here in Rapid City. Judge Schreier was the trial judge and wasn't in state court, but we utilized a device called the order to show cause to eliminate a lien. And I learned a lot from Vern in the process of doing that. And so in Seattle, I had a case where, and I'm going to talk about a handful of these cases. The lien was for $501,000. The tortfeasor fellow was on a motorcycle, catastrophically injured. The total recovery is going to be $598,000. So out of the $598,000, if you pay all the medical bills, you've paid $501,000. So the the approach that we took, and following the same sort of approach with Vern's situation, is we instituted an order to show cause in state court to bring the plan into the proceeding before we release the tortfeasor. Because if we can get the plan involved in, we want to say to the plan, this is all the money we're going to get. Are you comfortable with this, knowing that you might not get all that you want? If not, tell us what you want to do. And if you want to, you can substitute your draft for the $588,000, and then we won't release the tortfeasor. And so we have to have a vehicle to get the plan in front of a judge. And so we do that with an order to show cause. So we did that in Seattle. The attorney hired me as Mike Maxwell, and the plan filed a notice of removal to federal court on our order to show cause proceeding, and then filed a separate preliminary action against Mike and the client, always suing the attorney and the client. So lawsuit number 2 was a direct action in federal court. And we had a double success. There's a body of law out there that's grown ever since I've been involved, thanks to the Seattle case. And that body holds that recipients of an order to show cause do not have standing to remove a case. Only defendants, as allowed in the statute, can remove a case to federal court. And there was some precedent before, and there's even more precedent now, that if you can bring an entity into state court as a recipient of an order to show cause, that entity doesn't have standing to file removal, even on the basis of diversity or federal jurisdiction. And so the Seattle judge agreed with us, remanded the case, entered an award for the order for attorney's fees on the remand on the notice of removal, and then later ruled in our favor on the direct action, dismissing that case. So we had a double victory there. Judge Marcia Peckman was the judge. I was the ghostwriter. I was not attorney of record. I was helping Mike. Mike did I drafted every pleading, motion, brief in both proceedings, and Mike's name was the original counsel, so I was the ghostwriter. But when it came time to submit the affidavit for attorney's fees, I'm the only one that kept track of my time. I always do that. And so I submitted all of my time at a ridiculously low rate in terms of ERISA. I'm embarrassed to say what it is, Matt, so $160 an hour. I'd be asking $450 an hour and be awarded that probably. But we got awarded 100% of our attorney's fees. Mike didn't even request any of his time because he didn't keep track of it. And so exhibit number 1 is that order granting us the attorney's fees. And even though I'm not an attorney of record, the judge put my name in the order, so I appreciate that, just to prove that this happened, and we were there when that happened. Now, at that point, I decided, this is in 2010, I decided, why don't I just start doing this directly, being attorney of record? And I've got to tell you, and I've already done it by email, but I'm not joking, I was persuaded in part by going to the law school courtroom in around 2004, 2005, or 2003 when Jeff Viken came and spoke. And he and I were born in the same year, so we're about the same vintage. And here is this very established lawyer who had an incredible career in the U.S. Attorney's Office, private practice, and he was going to chuck it all and become chief public defender for North Dakota and South Dakota in federal court. And I'm thinking, what's this guy doing, Well, I think he knew what he was doing. And I was impressed by that, the ability to change course later in a career and to take on new things. I mean, why be pigeonholed in something? And so I got a little bit of, and then, you got appointed federal judge. So, but I was encouraged by that, and so at age 58, I started becoming directly involved in federal litigation, appearing pro hoc vici. And that means appearance just for this one cause. And so I've become pretty skilled at filing applications for admission pro hoc vici. I've been admitted pro hoc vici in a number of federal district courts. I'm like a kid in a toy store. It's so much fun to see where this is going to happen. And I go read the local rules, and they're all different. Some are burdensome, some aren't so burdensome. I'm really proud of the fact, for whatever, I really wanted to do something in the Southern District of New York, SDNY. I teach all these cases from SDNY. It's a huge hub of litigation. Famous federal judges were there, and I did. I got a case there, and was admitted pro hoc vici. I've become an expert and it's fun to read the rules. I've gone to the South Dakota Supreme Court repeatedly to get a certificate of good standing. In some instances, I'm also on inactive status in Missouri and Texas. In some instances, I have to go there and get a certificate of good standing, even though it's on inactive status. I had to do with that Southern District. It was the most burdensome one. Wasn't that burdensome? You can do it, but I had to give them everything for that. I really enjoy the hours I spend doing that. And you know what I call those hours, Quentin? Billable. Billable hours, researching these fun things, writing a letter saying, give me a certificate of good standing. Now here's an interesting twist. I just wanted to share this with you. I'm on inactive status in Missouri and Texas, and I had a case in St. Louis and Springfield and Kansas City in Missouri, and I had some in Texas, and I wanted to be admitted pro hoc vici. I can't do it. Pro hoc vici admission is not available if you're licensed in that jurisdiction. And the theory is, which is not user-friendly, is you should change your inactive status to active status. Well, I don't want to go through all that, and then NCL, so I became the ghostwriter in those cases. And so I always have a primary attorney who's usually a litigant, and so if they're being sued, so that's how I handle those. So I do all kinds of things. I have cases where I'm pro hoc vici as lead counsel, cases where I'm still ghostwriting. I have cases in state court where we're litigating this in order to show cause, and I had cases where there's just not even a federal element, sometimes just the state law issue. I want to share just 2 or 3 of these situations since I got active doing this. Your third document there is involved an ERISA lien, which I opened my file in May of 2010, and the lien was for $2,662,000 by the ERISA plan for the NBA, the National Basketball Association. And we had a wrongful birth case, damages at birth, and the tort recovery is $3 million. And so, now what these attorneys did is they hired me very early on, which is where I could be the most effective. So we could orchestrate things from day one. And so when about 3 years later, when they're on the verge of getting the $3 million, we instituted the order to show cause in New Jersey State Court, and that's document number 3 there. That's 14 pages, but if you go to pages 9 and 10, and they're not numbered, so you have to count them. If you go to pages 9 and 10, you'll see that all of the substantive rules, arguments were mine. And the attorney references me in the affidavit, recognizes me as making these arguments as having some expertise, and these are the reasons why the lien shouldn't be granted. And I also, in addition to providing that, also taught him how to do, learning from Vern Goodsill, taught him how to bring the order to show cause proceeding. And before the return date on that order to show cause, we received 100% relinquishment of the lien. The NBA said we don't want, well, actually it wasn't the NBA, it didn't have anything to do with it, it was the insurance company for the NBA that gave up. It also helped that in between, or it wasn't too long before that, I got involved in Walmart versus Shank, which had a lot of national publicity and adverse to Walmart, and resulting in them changing their plan. So that was an interesting case, and in fact, I've had 100% success in all of my New Jersey cases. Been hired by these lawyers out there in several files. I want to talk about 2 federal judges. In July of 2011, I was hired in a case in Connecticut where the attorney and the client were sued by the plan. And so this is what I say don't do. Well, they got sued by the plan. And the case was assigned to the Honorable Mark R. Kravitz. And I got to just love that judge. It was really sad because when I got involved and when the case sued out against us, he was a victim of Lou Gehrig's disease. He had ALS, and so he was on his way to not being with us much longer. But it also so happened that this Judge Kravitz was the trial judge in the Supreme Court decision Cigna versus Amera, which was handed down in May of 2011, about 2 months before this case. And that wasn't an ERISA subrogation case, but the holding of the Supreme Court in Cigna versus Amera was that in the world of ERISA, you have two types of documents. One's called a plan document, and the statute says there's got to be 4 things in that. And then the other document's called a summary plan description. And it's usually not very brief at all, but that's the legal term, summary plan description, or SPD. And so an ERISA plan that's operating the way it's supposed to has a plan document to comply with that statutory provision and a summary plan description. And almost all of the subrogation provisions are in the summary plan description, not in the plan document. Cigna versus Amera held the terms of a summary plan description are not enforceable in federal court. And it's just simply a reading of the statute. The statute says you can enforce the terms of the plan, not the plan not the summary plan description. And so I had a tremendous impact in my world. And so I was in front of the judge who was a trial, and this Cigna versus Amera was a very complex retirement plan case with all kinds of different beneficiaries at different levels, and things got shifted around. I mean, the opinion's like hundreds of pages to sort through all that. But that holding is crystal clear. And so the attorney who sued the lawyer and the client is in that national law firm that Mark Connett is in, Fox Rothschild. Okay, so she sued it out, and so I got hired, and so I filed a motion to dismiss, pointing out Cigna versus Amera, because she was seeking to enforce the summary plan description. And before I knew it, she withdrew from the case. She was gone, and then 2 other lawyers came in, and so we had to do battle with them, and they filed an amended complaint. And so this case is now pending in front of Judge Kravitz, and we file all kinds of motions and have discovery, and I love the telephonic conferences. He was just a cool guy. I could just tell, well, Professor Barron, what do you think about this, in the telephone conferences. And, all of our motions were in, discovery's completed, and we're going to have this big final hearing, oral. He liked to have the oral hearing. And so I offered to go there. It was going to be in March of 2012. And so I could have done it over spring break or canceled classes, and he didn't want me to be there, so we did it over, and so that was in March of 2012, and then in September of 2012 he passed away and never decided the case. One of the reasons why I think he didn't decide it was because we were waiting the result of another Supreme Court decision on McCutcheon, which was pending in the Supreme Court, an ERISA case like this. But in any event, he didn't decide it. So then it got assigned to, what's his name now? Judge Michael P. Shea. And there were no hearings or any further proceedings in front of Judge Shea. And then in June of 2013, so well over a year after we oral argued it, he handed down an adverse decision, so we lost that. And I keep thinking what maybe Judge Kravitz would have ruled. But in any event, it is what it is. So I lost that one. It's painful to lose those, but it's when my record with cases where the attorney and the client have breached the terms of the plan and then are sued, my record's about 50-50. And that means there's 50% of those that are just flat out losses. I actually think it's about 60-40, but those losses are so painful, maybe I give them too much weight, but I have some victories there. The other case that is this one in the Southern District of New York. Once again, the attorney and the client were sued because they settled and released a tortfeasor. And this case was assigned to Judge Robert Patterson, Jr. And at the time he got the case, he was 89 years old. I did a little research on him. His father, Robert Patterson, was the Undersecretary of War for Franklin Delano Roosevelt, and then became the Secretary of War for Harry Truman. So I guess he was a Secretary of War when they dropped the bomb. But in any event, a rich history and background to this judge. He did sign the order admitting me pro hoc vici, so I value that. He died in 2015. But in this case, we came up with some good arguments. We filed one motion for summary judgment. It was still pending. I filed a second motion for summary judgment. It was really powerful. And the plaintiff's lawyer called us up and said, if you agree not to seek attorney's fees from us, we'll dismiss the case. And so that's how that one ended. So that was a good one. Spent a lot of hours on that, and you know what I call that time I spend? That's all right. That's all right. I've either appeared in pro hoc vici or drafted ghost complaints filed are used in Nevada, California, Illinois, Missouri and Texas, Minnesota, New Jersey, and New York. Okay. On the cases that I handle where the attorney and the client haven't breached the terms of the plan, never lost a case. Either settled it or got a result. And knock on wood, I mean, I can always gotten a good result, a result that the client agreed to or was better than that. And many of the cases were complete relinquishments of the lien, just as in the NBA case. I always talk about the 3 time frames in which people can come to me for help. One is as soon as the case walks in the door, which is the best possible time frame because there's many things we can do to orchestrate this. The second, and then up to the release and settlement. I've had a lot of attorneys who say, I've got a deal, we've got an agreed amount of money, we want to release a tortfeasor, is it okay to do that? And I say, no, we got a lot of work to do. And I can still be effective in those. And I've never had a bad result, but it puts everything on hold. And of course, they're like looking at everything you do because they want a result right away, and you can't usually get a result right away. But that's what happens. I've come to see the role that fear plays in personal injury lawyers when they get sued in federal court or about to get sued in federal court. And you know, that's the people on the other side are very skillful in knowing how to use that fear to their advantage. And they're very skillful in making it appear as though, and I thought this for a period of time, appear as though the federal courts really don't like plaintiffs' lawyers and plaintiffs and tort victims. And I found that to be a false supposition. I found that to be absolutely untrue. Federal judges, as any judge, aren't real favorable to people who are breaching terms of plan documents, and that's the problem. But it's the complete opposite if you go into court on a declaratory judgment action and try to get this resolved ahead of time. And so that's, you know, I have a lot of cases where what has evolved over time now is that usually what I recommend when I get hired is let's go to federal court first and file our action, and let's be plaintiffs. The show cause thing works, but it takes cooperation by the trial judge, and we ran into some state court trial judges who weren't willing to enter this order to show cause. It's done ex parte. Most procedures it's done ex parte. And so we've kind of like, well, I can't do it. So what's the alternative? Let's be plaintiffs in federal court. And what first started being the alternative now becomes one of the most powerful positions we can be in is to plaintiff in federal court on ERISA. And the attorneys I work with almost always are very leery of federal court, these personal injury lawyers. And they're not keen on going to federal court. And so they want to do something like sue the plan in state court, and then if you do that, the plan's going to remove it. It's automatic. The plan is not going to stay in state court if you just sue them as a defendant. And I've always been, and this might be the most important thing you hear today, because this applies across the board, I've always been guided by one of the principles that I've used in my civil procedure book, and that is plaintiffs who file lawsuits in federal court win 58% of the time, 57.97%. Plaintiffs who file lawsuits in state court and are removed to federal court win 36.77% of the time. Huge difference. Huge. And that's across the board for diversity, for rising under jurisdiction, and it's been consistent over decades. Roger Claremont, law professor, a scholar in federal jurisdiction, follows these statistics. And so I followed up on them because the first statistic I had came from a book that was from 1998, and then he has a more recent one that came out in 2009, and it's almost the exact same numbers. And so why would you ever, if you know ahead of time that your case is removable and the other side's probably going to remove it, why do you want to disadvantage yourself by filing your lawsuit in state court, knowing it's going to get removed, and then you put yourself into that category? And so let's go to federal court, and let me try to figure out how to apply pro hoc vici and spend hours doing that because I like doing that. I want to talk about one last file I handled. This lawyer called me in November, last November. So this is one of my newer cases. This is not my most recent. I've had 3 files since this one. He happened to be in Fort Smith, Arkansas, which is pretty close to where we live. And he'd been around a while. He's a good personal injury lawyer. And he had a motorcycle victim. The client was on a motorcycle, and the lien was $401,000. And there's just a limited amount of money. Don't know exactly how much it was, but it was less than $1 million that they were going to recover. I think it was less than $800,000. And so he was being hounded by an attorney in Ohio to collect this lien. And this attorney was saying, you know, how are you doing? Well, we're pursuing the case. We don't have any money yet. And so he was communicating with him. And so when it looked like he might collect money, the attorney in Ohio, a fellow named Matthew Anderson, he said, you need to sign a written acknowledgement that you'll pay our lien. And that's when this guy called me. He said, you know, I don't want to do that, you know. I don't want to sign a written acknowledgement to pay his lien. I don't want to pay the lien, you know. And he said, what do I do? And I said, well, let's file a lawsuit in federal court. He didn't like that advice, and so I didn't hear from him. And so he hadn't hired me or anything yet. That was in November. And so as we got closer in January, I mean, the money is really on the table now. And they haven't, he did know enough not to go ahead and take the money and release the tortfeasor, so that's still pending. And so then he on his own sues the plan in state court in Arkansas. And then he sends me the pleadings, and he says, okay, I need you to hire you to take care of this. So now I'm hired, I'm on my hourly rate. And so I call him, I said, you know, this is removable. Well, why is it removable? I said, because this is an action that could have been filed in federal court. That's all you need for being removable. You know, any action could be filed in federal court. And I said, we could have brought him in on order to show cause if the state judge would have done that, and we might not have it non-removable. And the reason he called me is he just had another phone call with this man, Matthew Anderson, and this Matthew Anderson wanted him to sign this acknowledgement. And then he says, if you don't do, by the way, employers in Fort Smith, Arkansas, employees in Fort Smith, Arkansas, the plan administrator and the plan sponsor in Fort Smith, Arkansas, the stop-loss insurers in Little Rock, Arkansas, the accident is in Fort Smith, Arkansas. The attorney trying to collect the liens in Columbus, Ohio. He says, we're going to sue you in Columbus and Ohio because the plan is being administered in Columbus, Ohio, because he's trying to collect this lien. And because the plan is being administered here, we have jurisdiction in venue. And sure enough, venue applies wherever the plan is being administered. And so he's saying, we're going to sue you in federal court in Ohio if you don't sign this written acknowledgement and if you receive the money. Well, we did some research, and this guy's been doing that. It's exactly what he's been doing, suing lawyers all over the country in Columbus, Ohio, because the plan's administered in Ohio. And so now this guy who's not keen, he's not keen on going to federal court in Arkansas, but he's really not keen on being sued in Columbus, Ohio. And I say, why don't we file a lawsuit in Arkansas first? Under Federal Rule 3, an action is commenced upon filing, and this is a federal action, so we can beat him. And the last time this attorney made this threat was on like a Monday. And I worked night and day. I worked 24/7, but it was really 24/3 because there's only 3 days involved. Worked 24/3, put this complaint together, and we filed it in Fort Smith, Arkansas. And I signed the application electronically with application for admission pro hoc vici pending. And that's document number 4. And that's a 10-page document. And if you happen to read paragraph 22, you'll see that the allegation there is that this attorney made that assertion on 3 days before we filed it, but we got it filed on time. And so you can do that. Most courts will allow you to file by signing, and then it takes time to gather these certificates of good standing together and put together the affidavit and get those approved. And so I had that Judge PK Holmes III, don't know him personally, never met him, but he was assigned to the case. And so he granted my application pro hoc vici after I got my paperwork in order on March 2, 2017, and the case was settled less than 1 week later. So it's a done deal. Now, the other side of the story, or as Paul Harvey says, the rest of the story. I wanted to have something special for you folks. And so I put myself out. I called the attorney in that other case that we had found, in one of these other cases that we had found, that this Matthew Anderson had proceeded this way in Columbus, Ohio, and is an attorney in Missouri. And he too had a case where the employer was in Missouri, the employee was in Missouri, that plan. It was even better than our case because there was a forum selection clause in the SPD, or the plan document, that chose Missouri as the forum. And he listened to the devil. He went ahead and collected the money and put it into his trust fund. And he told Matthew Anderson he did that. And so Matthew Anderson immediately sued him. And reading from my notes here, not a client, nothing confidential, he just gave me this information. And I told him I was going to use it in this presentation. So Anderson filed that lawsuit at 4 p.m. On whatever day he filed it. At 9:30 p.m., he phoned him at home and said there's a federal judge that's going to hear the TRO tomorrow morning, the application for TRO. And so when this attorney went to his office shortly after 8 o'clock, he gets a phone call, allegedly, he said he didn't believe it, but maybe he should have, allegedly from a federal judge. So his paralegal's on the phone, and he instructs his paralegal to tell the judge that he's not available. The federal judge then decided to hold a contempt proceeding for what might be a falsehood in that little representation. And so the federal judge entered order to show cause against him and the paralegal and ordered him to show up in Columbus, Ohio. He talked to communicated with the court, said, "Can I do it over the phone? It's a long way." No. If you don't come to my courtroom, I'm going to send the federal marshal to you, and you will come to my courtroom. Okay? This is a worst case scenario. I mean, absolutely. He's got a paralegal who doesn't like to fly. So they get in their car and they drive to Columbus, Ohio to be in front of this federal judge for this contempt hearing. He hires local counsel just for the contempt hearing, costs him $20,000. Okay. He and the paralegal are forced to testify. She's reduced to tears, he tells me. And they're both held in contempt and he's fined. Now, that's kind of a worst case scenario. So I let my guy in Fort Smith know, hey, remember what could have happened to you? This is what happened to this guy. So, I guess what I want to say in terms of keeping with the title is don't let a fear become a self-fulfilling prophecy. And don't assume a court is against your client or against you. And when you start assuming that does become a self-fulfilling prophecy. And I see that a lot in my work. I work, obviously, with nothing but plaintiffs' lawyers. And some of them I really, really like. The majority of them, they call me, they want a quick fix solution. If it's going to cost them any money, they're done talking to me. And there is no quick fix solution to these things. You have to be patient, just like the MBA case. That file was open for 3 years before we got it resolved. And, sometimes, to take this out of ERISA, did a little family law for a while. And I have repeatedly been in situations where we have a custody dispute that's about ready to be litigated. And been in situations where one parent's in state A and one parent's in state B, and then the parent in state A, there might be a proceeding in state B or vice versa, and then there's this, what do we do here? What do you get under the UCCJA? What do you PKPA? Can the court do this? Blah, blah, blah. My advice always has been in the last couple of decades, if you're not in state B and that's where that proceeding is, why don't you find out if there's any reason why you shouldn't go there and litigate it? Because if you go there and win in state B, you're done. And don't assume that the judge in state B is going to rule automatically for the client in state B. You might be surprised. The client in state B might have a bad rap with the judge in state B. And if you put a dispute that's teetering on getting into this intractable conflict between state A and state B, where each has to go up through the appellate court system, what happens? You don't get a quick resolution. The kids are in limbo, and I always say, well, why don't we explore going there and litigating it there? And you can take a lot of wind out of your opponent's sail if you show up in the courthouse where they live and litigate your case, and you might just win that case. And if you win it, there's not going to be any having to take this to another state to get this approved. And so I don't know. I mean, there's other facts that can vary that, but don't be under the supposition in that divorce case or that custody litigation that the court in the state where your opponent lives is going to rule for your opponent. I think that's a false supposition. And that may be warranted. I mean, if you contact local counsel who's experienced and he says, well, this judge has never ruled for a father in his life, and you represent the father, you might want to avoid that. But otherwise, I don't know. I'm really pleased to be here. I didn't figure out how to end this on a nice, neat note, so I think I'm done. I'll take questions, though. Anybody has any questions, I'll be glad to feel. Yes, Terry.
Removal from state court to federal court versus direct filing. If the facts and the law are the same, what are your theories as to why that percentage would vary between 36 and 58%?
Well, I think from what I've experienced, plaintiffs who sue in state court and get removed to federal court, those lawyers, a lot of the times, are just totally surprised. They don't see it coming, and they don't practice in state court, and in federal court, and so they got a chip on their shoulder against the federal court to begin with because they don't practice there, and so to some degree, I think that's because the whole thing just disintegrates. And this doesn't include the settlements or anything. This is the final. A lot of those are diversity cases. I think in a diversity, well, it can be diversity arising other, but I mean, in the ERISA setting, if you're you're scared of that federal judge. That's what they are, and I guess they conduct themselves otherwise. I don't know, but I just know flat out these statistics are the way they are, and they've been that way for 2 decades. But that is interesting to see why. Other questions or comments? Oh, come on. Have I gone over the 30 minutes? Judge Woolman had to leave, so I'm out of time. Okay. Okay, well, thank you very much.
Thank you, everybody. I do believe